This morning on Nightwatch, can William Kennedy Smith get a fair trial?
The tactics by the prosecutor here were designed to take advantage of the gag order, were designed to prejudice everybody against Kennedy Smith.
I'm a little bit more confident that jurors can keep an open mind, whatever they have heard.
The importance of character acting.
You get to supply some piece of information about a person. And I think that's what's thrilling about acting for me, is this ability to show something about humanity.
Magical Mento music.
Take me back to the island in the sun. Take me back to the sunny land of fun.
Also, the thinking on artificial intelligence and sculpture from Zimbabwe. Now in Washington, here is John Hockenberry of National Public Radio.
Good morning. There's no disputing that the William Kennedy Smith rape case in Florida has turned into a media circus. Smith, the nephew of Senator Edward Kennedy, is accused of raping a 29-year-old woman at the Kennedy family estate in Palm Beach on March 30th. Last week, defense attorneys won a postponement in the trial after the prosecution made public sworn statements from 3 other women. The women claim Smith raped or tried to rape them in separate incidents. 2 people join us now to look at the many legal, social, and political issues the Willie Smith trial has raised. Paul Rothstein is a professor of law at Georgetown University. He is the immediate past chair of the American Bar Association's Criminal Procedure and Evidence Committee. And from Miami is Jeffrey Weiner, President-elect of the National Association of Criminal Defense Lawyers. He practices in Florida. Welcome to both of you.
Thank you very much.
There's a lot to talk about on this case, and I'd like to direct to both of you something that I've noticed in the past few weeks, in that while there is plenty of tabloid interest in the William Kennedy Smith case and plenty of kind of prurient voyeurism going on in the media, there's also an opportunity here to learn something about the criminal justice system in a way that a lot of these trials don't, it seems, offer. And I'm wondering if that's your case, if that's your impression, or if this is just another kind of media circus that's going to go on and then end. I'll begin with you, Jeffrey.
Well, I think it is a wonderful opportunity. The press is very much on top of this case, and I think the public will have an opportunity to learn a lot more about the ramifications of pretrial publicity, very prejudicial pretrial publicity, and how it can affect the right to a fair trial for someone who, by law, at least in theory, if not in fact in America these days, is presumed to be innocent.
The pretrial hearing really involves issues concerning the media, the question of television in the courtroom, the question really of venue has to do with the media as well. What kinds of issues are being raised in the pretrial hearing, Paul?
Well, what they're worried about is that all of this prior information about alleged prior sexual assaults by William Kennedy Smith is going to bias prospective jurors, that even if it's ultimately ruled inadmissible, the prospective jurors will have heard it and that they will have made up their mind that William Kennedy Smith is guilty. If you let some time elapse, 60, 90 days, maybe that'll die down a little bit, and if you change venue and move it out of Palm Beach, maybe you can find a place where people haven't made up their minds. I'm a little bit more confident that jurors can keep an open mind, whatever they have heard. And I worry a little bit about all the talk about clamping down on the press, that they should not report these things. There are some very important questions here of law about, for example, date rape. Should it be criminalized? Shouldn't it? About admissibility of evidence, the past sexual history of the victim and the past alleged sexual attacks that William Kennedy Smith supposedly perpetrated. Should these be admissible, inadmissible? This is not written in stone somewhere. The public can change these things, can change the law. And unfortunately, they only get interested in these things when there's a high-profile case. So there is, as you have said, an educational value. Our society has failed to address the question of whether this educational value is outweighed by the invasion of privacy. Maybe it is, maybe it isn't, but I think somebody should give some serious thought to this.
What do you think, Jeffrey? Is it possible to have a fair trial in the courtroom, even as we are educated?
Certainly, without the continuance being granted, it would have been absolutely impossible now. The surveys which have done which have been done to basically show that a significant number of people already feel that Kennedy Smith is guilty based on the very prejudicial release of these alleged prior similar acts by the prosecution, which were done really for the sole purpose of trying to prejudice prospective jurors prior to the trial. The prosecutor, had she done it, to my way of thinking, properly, she would have done it under seal so that there would have been adequate time to investigate those matters and to make motions before the trial court so that the trial judge could determine whether or not some or all of those alleged similar facts actually come into evidence.
Now,
There's
it's
absolutely no other reason to release that information.
It's my understanding, though, Jeffrey, that the defense was aware of at least one of these incidents prior to the prosecutor's release.
Well, there's been a lot of speculation as to what they might have known, but the fact of the matter is, John, that under Florida law, if the state intends to introduce such similar fact evidence, they're under an obligation to advise the defense. In this case, it was done not only to advise the defense, but to advise the media as well, and to make everybody around the country who was interested enough to follow this story, and it would be difficult not to follow it, considering all the media attention that's been given, to have the public feel that this fellow's got to be guilty, that in the past he has acted in a similar fashion, although that's yet to be determined. And even though he has not ever been charged with any of those alleged offenses, he nevertheless now is forced to be on trial for 4 acts instead of the 1 act, which was the basis for the criminal charges.
What do juries do in response to tactics like this of prosecutors? And is there any temptation for a prosecutor to ride this trial into a congressional race 2 years from now, for instance?
Well, you have asked me to speak on behalf of the prosecution because I'm a law professor and do see both sides of it. So I will represent the prosecution point of view here. I think that the prosecution was angry that details about the sexual background and sexual history of the victim had been released to the press. And therefore, the prosecution here thought we'd better set the record in balance and introduce some of the things that are being said about William Kennedy Smith's prior sexual conduct. It's my thought that the battle should not be fought out in the public arena, but if one side's going to do it, the prosecution understandably thinks maybe they have to respond. It's not entirely clear whether this former conduct of William Kennedy Smith will be introducible in evidence. The rules are somewhat flexible on that, and there is a decision for the judge to make on that. If the prior crimes really did occur and really are very similar in the way they were carried out to the present charge, then it probably will come in. Quite frankly here, they look much too dissimilar to me. It's not very distinctive the way the earlier acts were carried out, throwing someone down, pinning them down. That's allegedly what he did here. That's not very similar. It's not like the earlier case in Florida where someone lay in wait in a car on the back seat on a parking lot, said they thought it was their brother's car, that they were just going in for a snooze each time they were apprehended. That method of operation was carried out several times. That's very distinctive. In addition, there's not very much proof here that these prior sexual attacks really occurred. But speaking for the prosecution, I would certainly have given it a try to get it into evidence. They are going to give it a big try, and maybe I would have been tempted as prosecutor to try to set the public record straight and let the public know about some of this stuff. Now, actually, I think that by releasing it into the public, we have fault here on the part of the judge and the prosecutor. I think, speaking now abstractly, not for one side or the other, the prosecutor should have gone to the judge and also should have told the defendant, I'm about to file this information. But it's also the judge's fault. The judge had entered a gag order that only applied to people speaking about the case. Nobody connected with the trial could speak about the case. Filings in a case, written filings, follow the ordinary rule then of being filed and then they're open to the press. So the judge should have entered an order that covered written filings as well.
More to talk about. We'll be back in just one moment with our 2 guests. We're talking about the Willie Smith trial in Florida. Nightwatch will be right back. Interesting pre-trial motions last week in the William Kennedy Smith trial. We're discussing some of the issues that judges and prosecutors and lawyers are dealing with in Florida. Jeffrey Weiner, what do you think of the prosecutor's tactics here, and is there a wider context for a prosecutor to try to advance his or her own career in a really notorious case like this that makes the rights of the accused somewhat precarious?
There's no question in my mind that the tactics by the prosecutor here were designed to take advantage of the gag order, were designed to prejudice everybody against Kennedy Smith, and that the conduct here was reprehensible, to say the least. There is no question that the conduct here was premeditated by the prosecution, and that what has resulted from this release of very speculative alleged conduct can hardly be considered to be legitimate for any purpose other than to prejudice potential jurors and the public at large. And I think we have a problem when prosecutors have the mentality of win at any cost, and they don't take seriously their real charge, which is to secure justice and to protect the presumption of innocence.
Oh, isn't win at any cost a value often associated with defense attorneys as well?
Well, some people might associate it with both sides, but the fact of the matter is that the prosecution has an obligation to seek justice and not merely to seek convictions. A defense attorney has the duty and obligation to protect vigorously each and every one of his client's constitutional rights. And one of those is the presumption of innocence, which these days, unfortunately, seems to be more theoretical than real. And it's a real shame when something like that happens. I notice even a distinguished guest and a distinguished lawyer like Paul rarely use the word alleged when talking about these alleged prior acts of Kennedy Smith. And when somebody like Paul slips into that way of thinking about these allegations, then the general public will as well. And I think that this young man's future has been severely harmed based on allegations which are unproven at this point.
Actually, when you review the tape, you will see that I did use the word alleged because it is absolutely true. They are not proven. All there is allegations, and that's one of the problems I have with this kind of evidence. They are just allegations. The law does not seem to require, however, proof beyond a reasonable doubt or any kind of conviction or even that charges have been filed.
Well,
that's one of the problems I have with it. It sidesteps constitutional safeguards.
What is
he's
the law?
Charged with additional crimes here, suddenly dropped on him. They're not in the indictment. None of the constitutional safeguards like proof beyond a reasonable doubt or anything apply here.
Where's the law moving in this case?
Well, I actually think this evidence of the prior alleged sexual attacks will not come in, but it's a close question. The law is basically this, that it cannot come in simply to prove bad character, but it can come in to prove motive, intent, identity, similar modus operandi, that is, method of operating. But because the proof is so weak of the prior conduct, and because the modus operandi, the method of operating, is so common and not very distinctive and dissimilar amongst them, I don't think it'll come in. But let me tell you this, I think the prosecutor disserved their own case when they put this out into the public, because if they win this prosecution, there's going to be a big question on appeal as to whether there was undue publicity about this, and any win they get in the trial court might be overturned on appeal. So as a prosecutor, I would not have done it. Now, you, of course, have heard the theory that's circulating, that the prosecutors perhaps had done this on purpose because they wanted to jeopardize the prosecution because they're in the pockets of a rich and powerful family. I don't give any credence to that at all.
Nor do I.
But I will say this, that the prosecutors, you were talking, Jeffrey, about vigorous prosecution. In the past, prosecutors, when prosecuting the rich and famous, someone like the Kennedys, they've been criticized for not being vigorous enough, not trying hard enough, for somehow selling out. These prosecutors had to be very careful that they're not subject to that charge, and therefore they have to be more vigorous than vigorous.
What about...
Well, I don't entirely agree with that, by the way. I don't think they have to be more vigorous than vigorous. They have to be professionals, and they have to be lawyers first, and not policemen with law degrees and the power to prosecute cases. From the very inception of this case, pretrial publicity was carefully orchestrated by the police, by the state attorney who's running for office, and by this prosecutor.
Well, the Kennedys did some of the, publicity orchestrating too, don't you think?
I think they had to respond in order to, at least in some way, try to protect the presumption of innocence, which in this case is long since gone. And, it's sort of silly to think that the jury, if they should hear any of this evidence, can somehow follow the judge's instructions that evidence of other similar acts is not proof beyond a reasonable doubt of the crime which is charged. So
What-
the jury instructions and the very nature of this similar fact evidence is so prejudicial as to be really unfair the way it's applied if any of these prior acts come in from what we now know about them.
What about the past record of the victim? Where does the law stand on that, and how much of that information is protected or introducible?
Are you speaking with me, John?
Yes, Jeffrey.
Essentially, the law in Florida, it's called the Rape Shield Law, and the law in Florida is very similar to the Williams Rule analysis in many ways, and that is the prior sexual conduct of an alleged victim is not admissible unless it closely parallels the allegations raised by the defense regarding conduct of the alleged victim in the case. And it is a very similar analysis, and in this case, we don't know yet whether the defense will attempt to move that into evidence and how they will attempt to do that. That's yet to be determined, and it'll be determined by a hearing before the judge, not before the jury, prior to the trial beginning, or certainly prior to having any of this evidence presented before the jury.
Okay, hold right there. We'll be right back talking about William Kennedy Smith. Will he take the stand? Is that more or less likely given the developments of the past few weeks? Nightwatch will be right back. Talking about the trial in Florida of William Kennedy Smith, now in pre-trial hearings.
I wanted to ask Jeffrey on that point whether he thinks it is proper to reveal all of these details of the rape victim's sexual background that was done in this case and that's going to be forthcoming at the trial.
Paul, it's my feeling that, excuse me, in certain circumstances, the prior background of a rape victim should not come into evidence and should not be part of the evidence as a matter of fairness. On the other hand, if the conduct is so similar as to make it almost a signature pattern of conduct, then I think it's only fair that that evidence comes in. So I think it has to be limited to a case-by-case analysis, and if the rules are properly applied, then there are sufficient safeguards. But what really concerns me was the uproar about disclosing the name of the alleged victim when nobody, and literally nobody, seemed the least bit concerned about releasing the name of the almost defendant even before he was charged. So it's all right to ruin someone's reputation even before they're charged with a crime, but it's not all right to print the name of the accuser. Anybody can be accused of any crime in America today, and it's a shame that there are no protections for the person who is accused, such as, for example, in other countries where there is protection.
Okay, but until just last week, the feeling was fairly strong that Kennedy Smith was in the ascendancy, was really felt to be in a strong position up until the allegations that were released about prior sexual, problems.
I'm sensitive to the problem of William Kennedy Smith having his reputation ruined. If he is acquitted, however, I think he will be able to rebuild his reputation. I am a little bit worried about this rape victim's reputation. I mean, this is some pretty alleged rape victim, pretty salacious material, which has pretty peripheral relevance to the case, really.
Jeffrey Weiner, would you put Kennedy Smith on the stand?
Well, I don't want to be in the position of second-guessing my colleagues and friends who are defending the case. I think that's a matter that is best determined as the case progresses. It may well be that the cross-examination which is done during the prosecution's case-in-chief is so effective that there is no need to put him on. On the other hand, in a case like this, I think in probably a majority of the cases it's necessary to put the defendant on. Certainly the jury, in spite of any instructions which they'll be given by the trial judge, will want to hear from the defendant, and I would say the odds are probably that he will testify, although many times, even though the plan is for the defendant to take the witness stand, the state's evidence is so weak that there is absolutely no need for the defendant to actually take the witness stand.
With the squadrons of lawyers facing each other in this case, is there a chance it may never come to trial?
Well, depending upon what the rulings are respecting these two very incendiary pieces of evidence, the prior past background of the rape victim and the prior alleged sexual assaults of William Kennedy Smith, one or the other side's going to see the handwriting on the wall. This is a case that really is one person's word against another until you add in one of these other pieces of evidence, and that could tip it one way or the other, because you really don't have much to go on. Sure, you have some scientific evidence, but all that can tell you is that there was intercourse. It can't tell you whether there was any consent, and that's the real problem in this case. So once the judge rules on the admissibility of this incendiary evidence, one side or the other will see the handwriting on the wall, and there will be a strong incentive to plea bargain, but not until then. In my experience in criminal trials, if you don't put your client on the stand, the jury doesn't believe your client. But you have to ask yourself, does the client have anything to hide? I'm not so sure that he does in this case, because if he does have something to hide, then they'll ask about it on cross-examination if he's on the stand. If he takes the stand and says he's very respectful of women and would never attack a woman, that will open the door for the allegations that he attacked these other women. So he's got to walk that
So they're not
line.
relevant, so they automatically become relevant if he raises the issue of his own past.
Well, they might be relevant anyway, depending on what the judge says, but it increases the case for relevancy if he says something like that.
So even if the judge says not admissible, this stuff early on, if under cross-examination Kennedy Smith begins to talk about his background in terms of being a model citizen, that evidence could suddenly become relevant and we could reintroduce a motion?
That's right. Now, one thing that relevant to this that I wanted to ask Jeffrey that we perhaps went over real quick was turning it around and talking about the victim's past. If you allow the victim's past to be talked about, are rape victims going to ever come forward if they know their character is going to be raped again at trial?
Paul, it's an excellent question, and of course everybody is very, very concerned about protecting the rights of victims, as they well should be. At the same time, we've got to be concerned about protecting the rights of people who are accused of crime, because it can be anybody at any time. So the fact of the matter is that when someone makes a serious accusation, they should be prepared to go forward and to be subjected to whatever scrutiny necessarily follows making such an accusation. I think it's even more so the case when there's no physical evidence to back up a claim. So virtually no one is immune from an allegation like has been made in a case like this, and I think that scrutiny is absolutely appropriate. I'd also like to respond briefly to your comments regarding a plea. To my way of thinking, a plea in this case is very, very unlikely, and the ruling on the Williams rule or similar fact evidence, I don't think will produce a plea one way or the other. I think this case is going forward and is going to be tried.
Okay, Jeffrey, thank you very much. Paul, thank you both for joining me. Nightwatch will be right back in just a moment.
Still to come on Nightwatch, artificial intelligence, the genuine Jolly Boys, African art treasures, and an otherworldly actor. Now in Washington, here is John Hockenberry of National Public Radio.
Long before reggae, there was Mento, a rhythmic African-Jamaican hybrid music. In the 1930s and 40s, Mento was a favorite of the international set. The popular Mento group, the Jolly Boys, counted Errol Flynn and J.P. Morgan Jr. among its devoted fans. The Jolly Boys have been together in one form or another for more than 40 years. 2 years ago, they released their debut album, Pop and Mento. Their latest recording is Sunshine and Water. We'll be hearing some music from the four Jolly Boys a little later. First, we'll talk with Alan Schwimmer, the group's drummer and lead singer. Welcome.
Yes, welcome.
So great to have you here.
Very great to be here too, man.
Alan and I go back just a little ways from Radio Times last year. I saw you when you were touring in New York.
That's right.
And since then, you have spent all but 2 months touring.
Yes, call it about 3 months home. because I've been to Holland after I left to Spain, Switzerland, Scotland, Canada, a lot of different places in the United States.
And everyone likes Mento.
And everyone likes the music. Yes.
How do you distinguish Mento from reggae?
Well, to distinguish Mento from reggae now, the people would have to listen to the difference. Because the Mento was really the old music of the land before they have all these kind of instruments and maybe different musical ideas, because in those days they didn't even have much electricity in the island, you understand?
It doesn't take much electricity to run this baby here.
No, that's right, that's right. You see,
What is this here?
this is called a rumba box in Jamaica, but it's an African idea. It's a kalimba, a giant-sized kalimba.
Like the thumb
Piano,
Sure.
but in Jamaica we call it a rumba box because it's our bass, and you know rumba is a moody dancing, right? So it gets it, maybe his name is derived from that, rumba box. And I make this box myself.
It's good. And it's just a regular box, right?
Yes,
You
it's
built the box out of wood.
of cedar wood and ply, just like a guitar frame.
Got a hole in it there.
That's right.
One of our fine CBS microphones is hanging there. Otherwise, this is completely acoustic. You don't need
That's
to
right.
amplify
No,
this baby here.
no, unless on special occasions, like when you have hundreds of people, then, you know, to make a bigger sound.
Well, let's hear a few
Yes.
notes. It's like you can keep the beat and do the bass line at the same time.
Yeah.
What do they say to you on airplanes when you put that on?
Well, it's in a box. We have a box made for it, so they don't know what's in the box.
Do you change the little tines if you want a different note?
Yes, you see, as you notice, some is...
Nice.
You see, you got different sounds in them, and if you notice the different lengths that they have down in the box, that's what makes the difference. You get the pitch from that. You see, you send them down deeper. If you want to retune it, you have to loosen on these nuts here.
Just carry a wrench with you.
That's
No
well,
problem.
it's in the box.
It's in the box.
And the same wrench, it works on the drum and it works on the box.
It's great.
Yeah.
It's an easy life.
Yeah.
Get a wrench, a box, and a drum, and
That's
great
right.
music, and then people just call you up and tell you to come all over the world.
That's right. And if it needs to work, and sometimes these do got broken, you know, when they get too old and hot. That's why if you noticed here, there are some little tricky things about this box. You see, we have
put
to
some
put
grease
some
on there.
grease on it, and that allows your finger to leave it like that you don't feel much pressure, and it moistens the keys and let them last longer in the box.
Let's see. Tell me about this drum here.
Now this drum, I make this drum too, and this drum is made from a coconut trunk, a dry coconut trunk. So if you notice here, it was a solid bit of wood that I use as my gouge, because I'm a sculptor too. I'm a man of many moods. I do wood carvings and things like those. So I use the gouge to bore a hole through this and clean it out. In order that the prickles don't get in your hand, you have to take the handle off the gouge when you reach certain distance, and then you put it on a longer stick that you make. That you get leverage to prevent your hand from getting hurt down in there. And then it's a nice amount of work.
Oh, it's beautiful, and it's
Good texture, feel it, you see. It's like the coconut is like fiberglass.
Yeah.
And this is she-goat skin.
And this, you just go down to auto parts welding shop and
That's
get
right.
somebody to do
I
this?
buy the steel, I cut them in length. I go to the school and I tread well. I stopped doing that now. I cut it here and well on this and
Well, give me a few measures.
At the drum?
On the drum, why not?
If I just get my fingers dry, I do it.
Because we're going to take a break here in a second and come back and talk about the Jolly Boys.